So, ladies and gentlemen, dear colleagues, it is once again a great pleasure for me to welcome you for the 5th lecture within the lecture series on sovereign debt that has been organized at the Institute. I just recall that this lecture series has been organized with the support of the Fonds National de la Recherche du Luxembourg, that we thank again for this support. And I also thank, of course, the staff of the Institute, who once again have devoted so much energy to make this lecture a success. And I also thank, of course, Alain and Enoch, who have put together this lecture series. I'm really especially delighted to welcome today Mr. Philip Wood. And Philip, you have one of the world leading experts in comparative and cross-border financial law. And you work full-time currently for Allen & Overy, but you're among these practitioners who are not hostile to academy, because you have already been visiting professor at Oxford University and in other places. And we're really delighted that you have accepted our invitation to lecture today. You have written no less than 19 books in your field in a short period, and it's very impressive for an academic, knowing that you have a full practice beside this writing, and you have even issued recently a book for the general reader called, and the title is impressive, The Fall of the Priests and the Rise of the Lawyers. And so I hope that all our young scientists have in mind that they are belonging to a rising species. And so you have pioneered some methods regarding debt restructuring, but I will not go into this. This is your field, and you will explain. But I have to say that beside being a lawyer, a practitioner, you also run the marathon. And so this is impressive, for me at least. And you have also climbed the Mount Kilimanjaro in 2009. So I have to say that I have friends who have done this, and this is really an achievement, so congratulations. And I've also been impressed to learn that you have been awarded a CBE, so I had to look for this, because this is something that, as a French, I'm not familiar with. And it means that you're commander of the most excellent order of the British Empire. And this is also very impressive to me. And so I hope I didn't treat anything in your biography. But before giving you the floor, I would like also to introduce Professor Christoph Paulus, who has kindly accepted to be discussant on your lecture. Christoph, you're professor for civil law, procedural law, and insolvency law, and ancient legal history at Humboldt University in Berlin since 1994. And so you're also very comfortable with this field, and you're not only an academic, but you also act as an expert for the IMF as a consultant, the World Bank, and Ancitral. So you have a very welcome and authorized point of view on all these issues. So I'll let you the floor now, and thank you.
So, well, I was going to say, first of all, thank you very much for that most generous and kind introduction. And thank you very much for the invitation. I always love coming to Max Planck. I feel somehow, one is in a more spiritual realm. And especially in Luxembourg, which is a city I really love. I think this is the place where a few years ago I said, what's good for Luxembourg is good for the world. And I still believe that. So thank you very much indeed for what you said. I hope you don't mind if I sit down. The reason is that in the gym the other day, I had a slight accident. So believe it or not. So would that be, would that be all right? I mean, if you can't see, then do let me know. Anyway, this subject, it really amazes me for a number of reasons. I find it puzzling and perplexing because here we have a situation where I think, well, first of all, in the last 150 years, I think that practically every sovereign state, or one of its provinces, like the Confederate States, has been bankrupt in the sense they haven't been able to pay their debts as they fall due. I include places like New South Wales, except about 3 or 4 countries. I always say 3 or 4, because actually I can only think of 2, Switzerland and Finland, but I don't want somebody from some country to say, oh, you've forgotten me, and throw a stone at me or something, Indignant people get about things like that. I don't know about Bhutan. I haven't checked Bhutan, to be honest. But anyway, and it's amazing that, how, in the last 25 years, or a little bit more, certainly since 1980, about 45% of the world's sovereign states have gone through bankruptcy and a rescheduling. And that's an incredible number, almost half the world. And yet, when you compare the situation to, corporate law, where you have these incredibly intricate and complicated statutes which are worked on and refined and drilled down, and, incredible amount of effort goes into the design of all these, and rule books which go on for hundreds of pages. Still, in this arena, there's a complete vacuum, There's no petition, no provision for a freeze, no plan, no fraudulent preference, no stays, and no punishments of the victim, all of this. Nothing. It's just a vacuum. It's as though, and the lesson. So I have to say, what is the lesson? Is there a lesson? Is the lesson just simply, public international law, it's always, does things by consensus, they don't have any rules, they just sort of get along with each other, more or less. Their treaty law is, if you compare it to contract law, it's very thin, there's not a lot there. But nevertheless, the world gets on somehow because people, sort of believe somehow there is some sort of, rule about sorting things out, Some sort of Rousseau-esque social contract or something like that. So maybe you can say, well, that's just public international law, and the lawyers there, this is how they operate. And they're not really interested in all the muck and dirt of writing pages of rule books. It seems very inappropriate. And there's another class of people who think, oh, well, it works anyway, so what? So maybe that's a solution, or maybe there is some more profound reason for this. And that is, the best law is no law. Now, to me, that would be a very upsetting conclusion, to be honest, particularly in light of my recent book where I say, and thank you very much for the commercial, by the way, where I say, and it's a very bland statement, but I say you can have a society without its philosophies and its religions, and many states have, secularized, to be honest, seem to me. But you can't have a society these days without a legal system. You just can't do it. It's the one thing we have to survive. And it is the one religion, if you like, it's not a religion, of course, which everybody in the world believes in. Of course, they may not agree with the tenets, with the particular rules, but they all think we've got to have that. It's not going to work now on mutual forbearance. And here facing us is this incredible situation where there seems to be a vacuum. There seems to be a vacuum. So that's really what I want to talk about. I'm not going to try and influence you to take one view or another, to be honest, because I think it's quite possible, to take any view on this, and people do, don't they? And that's fine. So all I'm going to try and do is try and deal with some of the issues. And I think my instructions were, and obviously I have to carry out my instructions, I was to try and explain the contractual approach, because there are lots of people around who have explained or are going to explain. I think Lee Buchheit is coming along, it's a great friend of mine. I think he's going to explain the statutory approach, I'm not sure, or somebody is, and probably you may as well, Christoph. So anyway, that's my brief. So that's the brief I'm going to discuss. And what you need to think about is, does that approach help answer questions or does it not? That's the issue, which faces us. Now, I ought to say, I'm a great believer in the law. I really am. And I'm a bit of an addict, about the role of law. And by law, I don't just mean, I don't mean the 10 bullet points on the mountain with the burning bush. I know those are very useful points. But still, I think it's not just murder and sex, By the law, I mean the whole thing, capital markets, banks, money, corporations, clearing systems, tort, contract, intellectual property, all of that. Without those things, there'd be nothing on the plate for breakfast. And I include in that the very important private discipline of bankruptcy. Oh, bankruptcy is the great driver of private law. I mean, who cares? As long as you get paid, who cares if you get paid? Who cares even being cheated if you can get the fraudster and he can pay? The trouble is the fraudster goes bankrupt. And bankrupter is a great spoliator. It's a destroyer. It destroys whole societies because there's a victor and a victim. That's what the law does with bankruptcy. It takes decisions about who gets paid and who doesn't. It's called the ladder of priorities, the most important rule in bankruptcy. And that bankruptcy rule and the ladder are basically involve moral choices of one sort or another. And you could say even taxation, involves moral choices. Bankruptcy is special. And because it is such a ruin, it has such ruinous effects on sovereigns and on private people and corporations and so on, it rouses huge passions. And it gives rise to huge outpourings of law. I mean, when banks go bust, as they recently did, look at the law which we've had since then, absolute mountains of it. So it's the big driver. And that only deepens my sense of puzzlement as to why people, with banks go bust, suddenly we have 2,000, 10,000, 20,000 pages of Dodd-Frank and all of this, But nothing on sovereign states. Perhaps I ought to just finish there, Christoph, and you can stand up and say, oh, well, it's pretty clear. We don't need to hear your points. Are we okay so far? We'll see. Actually, a few years ago, I'm chairman of a group called the Sovereign Bankruptcy Group of the International Law Association. And we published... I think just me, because they couldn't find anyone else to do it. But it has got some very good people on it. It's got Lee as an observer. It's got Sean Hagan, who's the general. He's only observer because he's general counsel of the IMF. And it's got lots of academics on it. Christoph is on it as well. And it really is a sort of glittering group. Anyway, we published, the present group and the previous published papers. One is called the Hague Report, which was really just comparing sovereign and corporate bankruptcies. And it's of interest only, I think, because, apart from the comparison, was because it contains a sovereign bankruptcy statute, which I wrote on Christmas Day, 2009. Because it was a joke, I had nothing else to do, because what it's like on Christmas Day, you've opened your presents, they're not as good as you thought, and so you go up and sulk in your room, have a glass of mulled wine and some cake, and then you write a bankruptcy statute for sovereigns. That's what I did. Because, the best way to solve something like that is actually to have a go, and try and see what it says. And that's what I did. I think it's very good. But it was interesting because it brought out what we'd have to do if we did that, Anyway, we subsequently published a paper, which I think you may have, I'm not sure, the Johannesburg report of 2014. And that's where we tried to make recommendations. I don't think it worked particularly well. I think I had to write it at the last moment, for various reasons. I took in every single point which anybody made, and I think a lot of people didn't agree, but you can't get people to agree, on something like that. But I think they were too courteous. Anyway, it's got some points, and really points about the contractual approach, so you might like to look at those. Now, before we go down some of the things which contracts do, first of all, I thought it might be helpful And I apologize if this is, childish stuff, to explain what actually happens in a sovereign bankruptcy. And I'm going to do that because I want to show how incredibly simple it is. Probably why, I quite enjoyed doing it, because you didn't have to know anything, You just sort of had common sense. You could hardly imagine a simpler transaction, because it's just an exchange of bonds. At the moment, it's exchange of bonds. Most sovereign bankruptcies involve bondholders. Sometimes they involve banks as well, slightly more complicated, but normally it's just an exchange of bonds. And it's not like a corporate bankruptcy, which has employees and pensions and trade creditors and, enormous leases and landlords and taxmen and all of that. It's not like that at all. It is so simple, really simple. The sovereign state just says, I hereby offer to exchange your bonds. Send me your bonds and I will give you a new bond. It's not quite such a good bond, but nevertheless, it's a new one, It's good, isn't it? And that's all it is. And actually, in most countries, you don't even need any disclosure. In the case of Greece, by the way, I don't know why, but I sort of do in a way. I was one of the partners in my firm acting for the steering committee of bondholders in relation to the Greek deal, which I found, maybe I'll remark on that, but I thought was a truly fascinating sort of position. So the whole thing, you see, depends upon the bargaining position of the parties. And if I say there's no law, there is a law. It's called contract, And contract is, I think, one of the most imaginative things ever thought of. It is so beautiful and so useful. I don't know how many contracts there are a day. 5 billion? Something like that. So many, it's like the sun shining on a lake when the wind is, you have all these ripples of all these millions of contracts. I mean, so evanescent, but still every little purchase in a supermarket carries this crunching weight of these great books. Of course, they all disappear, quickly. But contract is just a wonderful invention which is used. And of course, it's used in this situation. It's wrong to say there's no law at all. But everything in the resolution depends upon bargaining position. And by bargaining position, I include geopolitical situation, the ability to refuse new money and so on. All of those are part of the game. And in that bargaining position, and this comes as a shocking surprise when you first meet, the banks and so on, insurance companies. By the way, I know that many people think, sovereign creditors are basically Draculas, They're hedge funds, and they're aggressive, and they run around the world harassing unfortunate states, and they drink blood and they eat children, this sort of thing. Well, they're not. I'll tell you, to be honest, and I don't want to be rude to anyone here, but the people, people at banks who do this sort of work in insurance companies lead very boring lives. They really do lead a boring life. They get up early in the morning, they go to work, they deal with all the office politics, they come home late at night, they don't even see the kids, they kick the cat, and say something. And so that's their lives. And look, actually, I don't know what they do at night, but, apart from that. So, and they're very conservative people. And the only one thing they want to get paid, that's the way they work. And if you say, what is in, I mentioned the side points, I'm not arguing for them, of course. But the side point is, their argument, for what it's worth, is that they represent the citizen. Because they got the citizen's money, and they're just a creative piece of fiction in the middle. When you switch on the lights come on. Why do the lights come on? Because they've been financed. Who's financed it? Often a bank. But who's actually financed it? All the people who put their salaries in the bank. So you can say that it's the citizen who switches the lights on, and in an insurance company, it's the citizen who puts his, his pension money and all of this and his premiums into the insurance company. The insurance company is just like a lake, that's all, which gathers all this rain. And you can say most of it's wasted and so on maybe, but we waste our lives, don't we? And it's not unreasonable. So that's their argument. So they say that they're not just something out there which is taking away people's property, that they represent an interest. And the interest is savers, and so they're creditors. And so you have creditors and debtors. But the people you think are the normal creditors are not, the banks and hedge funds and insurance. They say it's the people. So really what you've got is, is the people on both sides. That's why it's so ambiguous. It is. And anyway, look, I just put that in for you to consider. Now, in this game of poker which goes on, the cards people have are lousy. I mean, lousy. They mainly a two of clubs, a two of spades maybe. Maybe somebody's got a five of diamonds, but nobody's got any big cards. There are no aces there. There are absolutely no aces. And if you take Greece, for example, Greece obviously didn't have any cards. They were flat on their back. And they could only get a position by taking somebody else's position. And the Eurozone had cards, but very weak, very weak. They could have opened the taps through the FSF or something, They could have bought the bonds themselves. I think they could have. Could have been quite cheap. But in the end, they didn't really have a lot of cards. The banks had a huge card. I mean, a real four of clubs, because of the attraction of the euro. And you would say, that was an ace. And in fact, at the beginning, one of the things I said, look, you're going to be wiped. You're going to be obliterated unless you play your card. They've got this currency, and they really love the currency. And actually, I personally think that 17, one currency is better than 17. That's my view. Or a lot of people in my country don't agree, but that's my view. So anyway, it symbolizes something. And so I said, if you want to win this one, you play your big card, and it's a lovely big card. It's a good card. Don't lend to France and Italy. Finish. And then they'll take you seriously. And they looked at me in absolute amazement. They said, as I expected, to be honest, because that was a very cheeky, mischievous thing to say. They said, but we can't do that. Because, you don't pull a house down when you live in the house. That's number one. And number two, we are on the side of stability. There's a deal here. And the deal is something to do with us all working together, or I don't know, that's the deal. So that was, if you like, an altruistic position. In a way, it was. Because it's out the question, that particular thing. And that's also what the Eurozone thought. It wasn't just money. There was an ideal there that we have to have stability. So they also acted out of a sort of altruism. And certainly from the point of view of Greece, I mean, they think they founded the whole European idea, There was never any question of them leaving the currency or leaving the EU. It's the one thing they were not going to do. Why? Because there was a deeper philosophical sort of altruism here. And anyway, that's the way, as we were working through this transaction, I viewed it. And that's why it could have seemed very chaotic, to many people on the ground. Anarchic, all this argument going on. But it went like the wind, 9 months. Can you imagine doing 300 billion or whatever it was in 9 months with 17 countries and with Greece and all this? It went like lightning because it was driven by ideals of some sort. Also, bargaining position. The only thing we ever argued about, it's just an illustration of the bargaining. Obviously, there was big geopolitical points, Greece, the euro, all of that, which drove the thing forward. The things we argued about, there was the haircut, was it going to be 25%, 50 or 75? The bank just said, and of course, they did get wiped out. They only got 15%, in cash, and then a little 30-year note, which is not very valuable, to be honest. Valued nothing. So that was, that was a very good example of how a sovereign bankruptcy works and why it works. Because almost inevitably, you do have that kind of situation, why it seems to work so far. Anyway, to go back to the story, when a country sinks into bankruptcy, it doesn't happen suddenly. It happens over quite a long time, unless, like Grenada, there's some terrible storm which wipes them out. And then the economy collapses. But normally it sort of builds up over many years. And normally debtors are in denial. One thing's for sure, they always seem to be late. And there's nothing new about that. That happens in corporate bankruptcies all the time. There are all sorts of techniques of trying to get, corporations to admit it early on, like making the directors personally liable for deepening the insolvency and all these rules. But none of them really work, and they certainly don't work with sovereign states. But eventually the IMF gets involved. And sometimes states don't like to involve the IMF for the reason I'll give you, not because it looks bad, but because they lose control of the situation. Well, they get some control, they also lose it. Because you see, when the IMF gets called in, first of all, nobody reschedules without saying, you've got to have an IMF standby and company doctor austerity policies, all the stuff about you raise your taxes and no subsidies and all of that. And the official creditors won't reschedule it without that, usually, and nor will the private sector definitely won't reschedule unless it's an IMF program. So the IMF basically decides what happens. They work out the sustainability analysis, much criticized for doing that, but that's what they do, It's a function. They're owned by all the sovereign states in the world, and that's one of the things they do. So they work that out. And then the Paris Club gets together, and they go along and whisper in the ears of the members of the Paris Club, these are creditor nations who all meet together, and they say, this is what we recommend. And all the ministers of finance say, fine, we quite agree, nobody tends to argue. So then they call in the debtors, say, this is the deal, there's no real negotiation, to be honest. But that deal contains a clause in a minute. It's not a deal, it's a minute, it's not even a contract. God. So anyway, that's all signed. The minutes just record what's agreed. And it's got the statement in which says that the debtor will not give any other creditor a better deal. It's a comparability clause. So later on, when all the banks and insurance companies awake from their slumber and rush around and say, my God, we're not going to get paid to the Minister of Finance of the sovereign debtor, they say, we want this, we want that. And the Minister of Finance throws up his hands and says, I'm sorry, I've agreed this with the Paris Club, and I can't give you a better deal. Bye. No. So basically, under that scenario, the IMF is calling the shots. And they do. And it means that the sovereign debtor hasn't got any room, really. And the private sector don't have any room either to do anything about it, to be honest. So that's why the IMF is so important. Now, that, a lot of people say, well, the IMF's not accountable. So all those arguments, well, I'll leave you to consider that. So the next thing which happens is there's a moratorium on the debt. Sometimes we have the moratorium expressly stated. The sovereign debt announces it's not going to pay its debts, but it's going to talk to its creditors for 90 days and try and resolve it. Greece didn't make an announcement. They just sort of drifted along. It was thought better not to. Creditor committees get set up. There's usually a lot of arguments about the creditor committees. They insist on having their fees paid by the debtor. The debtor doesn't answer any emails about that issue. And so they negotiate a deal, and there's a lot of complaints about the deal, but eventually, everybody gets crammed down, and then they're told, out comes this document which says, we offer to swap your bonds. So that's it. That's it. And at the end of that process, you can see how terribly simple it is. At the end of that, just about everybody accepts the deal. Just about everybody accepts. It's usually about 95%. And we reckon in the corporate sphere, anything over 90, you're there. You're never going to get, people who are not going to do anything or don't want to or sulking. So, and that's what normally happens, except Argentina. Now, Argentina really put the cat amongst the pigeons because they didn't really talk to the creditors, and the creditors felt sort of shoved off. And Argentina said they were only going to pay them 25% or something. They'd take it or leave it. And I think about 76% or thereabouts took it. And then there was a litigation. A lot of the bonds then got bought up by hedge funds, particularly one hedge fund which had made quite a study of a little-known clause called a pari-passu clause. So they made a study of this. And they got into the New York court, and the New York court actually agreed with them on very slender grounds. I think the court disapproved strongly of Argentina's conduct. Anyway, the effect of the judgment was highly inflammatory, to be honest, because effectively the court, and I know technically they didn't do this, but they ordered a payment of a debt subject to the criminal penalty of being in contempt of court. Well, normally nowadays it's not criminal, you know. But that was a sort of, I know they'll say they didn't order that, but that was the overall effect. So here was this hedge fund running around the world trying to gather assets, being quite nasty, and here was a court in New York being very, very aggressive. Technically, you could say they were right, but it looked to the rest of the world to be quite aggressive. Now, a lot of people then thought, this is what it's always like. We're right about the bondholders. They're Draculas. They are Draculas. Look at what happens. And look at what the courts of the United States courts will do. The bullying and all of this, you know. And here's this destitute nation. Well, you can imagine. And that Argentina really has, I think, polarized the debate. They really, the whole situation, ridiculous as it was, introduced a deep emotional polarization to left wing, right wing, all of this. And it was very difficult to talk about these issues without this coming up. So anyway, history is history. We have to live with that. But all the point I'm making is that it was rather unusual. Argentina was an unusual case in my experience. So, okay. Now, there's just 2 points I want to make about that narrative. First of all, a sovereign bankruptcy rescheduling. By bankruptcy, I mean inability to pay debts as they fall due. If it's really serious, some people say it's a solvency crisis. If it's not so serious, they say it's a liquidity crisis. There's no real definitions. You know, you can't value a state's assets. Well, you can, but it's not like a liquidation. So all of those are very sort of waffly, woolly sort of words. But basically, people are bankrupt when they can't pay their normally foreign currency debts as they fall due. Now, in the corporate sector, 90% of those situations are resolved by a workout, a private contract between the creditors. Workout agreement. You know, we've got a whole department. This is what they do all day. 90%, I don't know whether it's 90 or 85 or 94.645 to 3 decimal places. I really don't know, but it's the most. People don't go to court. There's all sorts of disadvantages, you know, about going to court. Sometimes they go to the court, like General Motors at the end, to get the court to put a stamp on it so as to avoid the thing being challenged later. It's called a pre-packaging, you know. So we do a lot of that in the UK. They do it in a lot of countries, pre-packs, all the rage. But I'm saying to you that a sovereign workout is handled in the same way, not via a law. You don't have a court normally in these situations. All the bankruptcy law does is to be the man with the axe behind the curtain who comes out in the corporate sphere if people don't keep to the rules, which normally means keeping to the ladder of priorities. Those are the basic rules which courts basically administer when they decide whether it's fair or not, you know, in their court ruling. So to that extent, the sovereign procedure by contract is exactly what happens in the real world with individuals and with corporations. So the issue then becomes, do you need the law so that there is a man with an axe in case it gets out of control? And that is a good question, in my view. Okay. Anyway, this whole thing about contract and treaty, you know, if you were going to do it by treaty, the best way to do it would be to amend the IMF Articles of Agreement. You know, Harry Dexter White, I think he was a communist, wasn't he? And John Maynard Keynes, who was another very engaging sort of chap, who wrote the IMF Articles of Agreement, did put in an article, it was Article 8.2b. Nobody's ever heard of Article 8.2b, but let me tell you, it's rather important, which was their Chapter 11 for sovereign states. That's the way they thought of it, you see. And that article said that exchange contracts which are contrary to the exchange controls of a member state shall be unenforceable in the courts of a member state. So all IMF countries, that's everybody except North Korea and Bhutan, I'm not sure about Bhutan, have agreed that if a state passes exchange controls complying with the IMF rules, which are rather easy to comply with, then all member states will recognize that, thereby overriding and giving the state the possibility of unilaterally changing the deal by passing an exchange control. So for various complicated reasons, the countries, some European countries who wanted, after the Second World War, to be seen to be doing the right thing, it's quite obvious that Harry Dexter White and John Maynard Keynes thought that applied to all contracts. Well, some countries like France, Luxembourg, and Germany, to a degree, their courts decided that exchange contracts included bonds, so that applied to loan agreements. Whereas the courts of Belgium, England, and New York took the other view. They said, no, that just means an exchange contract, to exchange one currency for another. It doesn't apply because the effect was to override the insulation effect of their external governing law. That's why it was so important. By the way, we all went into this back in the 70s when Latin American countries were saying, we're only going to contract under Venezuelan law, Colombian law, Brazilian law, and all of this. So we had to work out why you had to have a foreign system of law to insulate against those changes, because most countries will recognize a change of law under the governing law of the state, whose governing law it is, like Greece, for instance, but not if it's the law of another country. So, for instance, Fiji can't pass a law which changes an English law contract, but Fiji could pass a law which changes a Fiji contract. And Greece could pass a law which changed the terms of its bonds, and indeed it did do that by putting in CACs, collective action clauses. And the only thing in that Greek deal we really argued over, except for the haircut and all that, was the governing law. And the only point, because initially the Greeks wanted Greek law, and so we argued around that one, said it's not appropriate because it is not market acceptable, all this stuff, insulation, all this. And then the Eurozone said, well, we want a Eurozone system of law. And that was really difficult because I had a very unpleasant task, because my instructions were, and I hate this because I'm a one-world guy, by the way. I really am a one-world, another thing I happen to believe in, apart from the rule of law and all that. I had to say why no country in the Eurozone, why their legal system didn't meet the case. And I couldn't do it on big ground, English law and all that. I had to do it on technical grounds. And the way I did it in a memo was by saying either the country doesn't recognize a trust, because we had lots of trusts in the structure, trusts and bondholders and so on, which took out quite a lot of countries. Or else they've got bad case law on Article 8.2b. Oh, rather technical. Anyway, that's why Article 10, and I only knew about that because of what we went through in the 1970s. So anyway, to get back to this article, the way actually to introduce a statute would be by changing Article 8.2b, just changing exchange contracts into all contracts or something like that. You only have to change 2 words. But the difficulty there, and I think people have latched onto this as how you do it, because then you see the country, IMF members don't have to pass a statute, because it's been agreed in the IMF agreement that you can make changes provided you, is it 87%? Provided you get a vote of 87%, or something like that, 84, I can't quite remember, then it's binding on all of the member states. Whether they have to pass legislation is up to them, but maybe not, So this is the neatest way, rather than doing model laws or anything of that sort. The problem there is the US has got 17%. So they've got a blocking vote. And so it would require either a change of the voting procedure in the IMF agreement, which is constantly discussed, or it would require persuading the US Treasury that this is needed. And at the moment, certainly their view has been traditionally that they don't want to do that. They really said, markets, you try and sort it out. So that's where we are on that point, to be honest. And if you say, well, what happens from here? I really don't know. I can't track what's happening in the damn world at the moment. I don't understand the world. Do you? Well, I don't get it. Anyway, so that's the root. You know, it always seems to be that. Now, there is another point behind underlying all this, which I think is very often misunderstood, and it was brought out in the whole Argentinian thing. You know, Elliott, you know, the hedge fund concerned, only got one asset, and they even lost that, and that was a military training ship in Ghana. And they even lost that under the law of the sea, you know. So, I mean, it's not a big deal. So what's going on there? The point is, and I think this is really fundamental because this is what the markets say. Again, I'm not expecting to agree with the markets and all that, but it's what they say. They say it's not like a corporation because sovereign states have got either legal or de facto immunity. It's impossible to attach their assets. A corporation, you can always liquidate them, you know, or you can attach their assets until there is a liquidation order. So, and the reason for that is that in every country in the world, practically, domestic assets are immune. I mean, either by law or in practice, you know, you and whose army, and all the stuff about, you know, attaching the Acropolis or attaching Crete was rubbish. You can't, in any country, creditors can't take the asset. So all the domestic assets are out, which are, you know, their assets, frankly. And you say, oh, well, what about the foreign assets? Because they always waive immunity, the widest possible waivers immunity in their bonds. It's because the foreign assets are not held by the state. They're held by the central bank. That's where the reserves are, if any. And all of the other assets are held by state-owned companies. The first thing a country does when it's in trouble, they will be advised by whoever's advising them, probably me or somebody like that, get your assets, you know, into state-owned companies, PDQ. And then you haven't got the state's not a debtor. Oh, there are a few bank accounts and all that sort of stuff, you know. So they de facto immune by virtue of the veil of incorporation. And there's case law about Bank of Cuba and all of that, about assets being transferred around. But the creditors never managed to crush, to strip away that veil of incorporation because the courts won't allow them to do that. So that's the situation. The other big difference, compared to corporate bankruptcies, where creditors have got a claim, you know, which they can enforce. The other thing is, in a corporate bankruptcy, the creditors can take control. I agree in the case of Chapter 11, the control's quite limited, you know, because management have got a lot of powers under Chapter 11. But in the case of a state, really, the only people who've got any power is the IMF. They have got some power, like a company doctor. So creditors often say, and please don't necessarily follow this, they will say these states have got an exorbitant privilege. They're not subject to the discipline of the law. The law doesn't apply to them in the same way it applies to me, our companies, and all that. That's their argument, for better or for worse. Okay. Now, so what's happened with contract? Well, I'll go through this quite quickly, shouldn't I?
Go ahead. Please go until 6, because I don't want to talk after you.
No.
No, I can't. Go ahead.
You better ask them, haven't you? Well, I'm not going on till 6. Anyway, I had all these points. I have to erase through them. I'm sorry about that, you know. It's not rambled on. Anyway, look, first of all, a big thing happened with collective action clauses. Those are clauses which now go into bonds. And there are all sorts of different collective action clauses, but the crucial one is a financial democracy, where creditors vote, and that binds the minorities. And to a lot of people, that's sorted. That contract, if it goes into the bonds, that deals with the question because you've got a plan. I don't think it does completely deal with the question because there's about 900 billion of bonds out there which don't have these clauses in them. and there are lots of other sorts of bonds where, it's not strong enough. It gets rid of all the Argentinian problems over the pari passu clause and so on. So to a lot of people in the market, they said, we did what we were told. Because the US basically said to the market, if you don't do this, we're going to review Harry Dexter White and John Maynard Keynes' work, because they were economists, so that's why they didn't work it out, didn't they? They used the wrong language. Okay, so you say, well, what's missing? Because there you have a financial democracy. And if that works, and if there weren't all these gaps, and there are some major gaps, like the legacy bonds and so on, then that is a major step forward in terms of replicating what happens in a rescue proceeding in the corporate sphere. Because a rescue proceeding in the corporate sphere is about the plan. It's about binding what's called the holdout creditor, Elliott, people like that, these hedge funds, cramming them down so they are bound by a majority vote, 66 2/3 or 75%. A lot of arguments about whether each issue has got a vote and all of that, but basically it's a financial democracy. And I think that was a great step forward. The Eurozone did it by treaty, and the market's done through one of their trade associations called ICMA. So that leaves, when you compare it to what happens in a corporate bankruptcy, there is no freeze on creditors in which you can negotiate. You can get some clauses which freeze accelerations where, 20% votes will do this. But basically the freezes are very light compared to a corporate bankruptcy. And I think that's open. I personally think that the market should develop stands. There's no reason why you shouldn't do it by contract, by having a standstill clause so that the creditors and everybody has got a breathing space in which they can discuss the matter. So I think that's something which is worth considering. The reason why there hasn't really been pressure so far is that attachments of assets have been so rare. By the way, when I said there's no attachment, there is one asset which they do attach, which has huge potency, which chills access to the markets. And that is they have an attachment order on the proceeds of future bonds, either the proceeds out or the repayment proceeds. And once you get that order, nobody's going to lend any money with bonds to that state, because just get attached. I know you can route the money through the IMF and all that, but it's very shaky, and I don't think it's too easy to do. So in that way, they have a certain power from that sense. Anyway, I think standstills are worth discussing. I think trustees are definitely worth discussing. There's a lot of arguments about trustees. Are they useful? They're not recognized in a lot of countries. They're not absolutely essential. They're incredibly conservative and so on. They can sometimes, people say, be more of a nuisance than anything else. But my own personal view is there's a lot they can do because they can enforce a pro-rata distribution. And when you're going through one of these procedures, I think it's useful to have somebody who is a sort of representative and can organize things. As for creditor committees, there are draft clauses out there which basically issuers, somebody to negotiate with, whose fees get paid by the issuer. Those just haven't caught on. Should you have to have a creditors committee appointed in the bonds? People differ. I don't think it's absolutely vital. It seems to work out, but views are divided upon that. So that leaves one big area of bankruptcy not covered, and that is priorities. And, when you look at these deals, priorities are really crucial. In a corporate bankruptcy, you've got 6 big steps. You've got the super priority, which are creditors with a set-off, creditors with security, and claimants under a trust. And the distinguishing feature of the common law systems, which goes back to the 19th century, nothing clever about them. It was just Adam Smith, laissez-faire, railways must be built, banks do what you like, capital is king, all of that. Big 19th century sort of philosophic view. The courts then, in the common law jurisdictions, gave super priority to those 3 claimants, when the other 2 groups of jurisdiction, which are the Roman, Germanic, and Napoleonic, I'm leaving outside transition and Islamic and so on, in the other 2 they didn't.
the Roman Germanic went with for 50-50 on that, and the Napoleonic for none of those, more or less. I mean, they're a terribly simple little sum. And that's because of the, well, just as an aside, probably because of the timing of the Industrial Revolution in those countries compared to the crystallization of the laws. The French were there first with these incredibly charismatic laws, but before the Industrial Revolution, the capitalist king actually took hold, and the Germans crystallized their thing in the middle of the Industrial Revolution. So that probably is extra. Anyway, this ladder of priorities, so in the corporate, you've got the three at the top, then you've got priority creditors, tax and so on. And then you've got the ordinary creditors, and then you go down to various expropriated creditors and subordinated creditors. You've got these 6 steps, usually in about 70 or 100 actual rungs. Now, in a sovereign bankruptcy, you can't replicate that because you don't collect the assets and then divide them up. But you do have a set of priorities, because if a creditor is paid on Tuesday and Wednesday's creditor then doesn't get paid, Tuesday was prior. So the priority is fixed by dates of maturity, except when it's more than 10 or years. In a creditor with more than 10 years, it's just equity, So they're at the bottom of the ladder. Now, in Greece, I counted that my clients were 10th. They were 10th in the ladder, because all of the Eurozone countries had, their own credits, which only went on for 8 years, whereas the banks had 30-year debts. And because the IMF and all these other people are at the top by consensus, not by anybody's agreement or contract, just by consensus. And so that was the effect. And so if you actually look at the ladder in a sovereign bankruptcy, they can have a lot of steps. Domestic creditors are outside, trade creditors are outside, small creditors are outside. What does that mean? They paid first. So you get this long ladder, 14, 20 steps, something like that, very often. Could you replicate that by contract? You could, but my God, that would be hard. I mean, I think contract can do that, but I think it would be very hard. And so if you were doing a statute, you'd have to deal with that. And my belief is it would be very, very difficult to get agreement, because the ladder is everything. The plan is just financial democracy, and the freeze is just a mechanical thing. But the ladder is not. The ladder, is everything, new money and all that. So I think that'd be very difficult. Anyway, there we are, my friends. Thank you very much. I've probably gone on too long. So, okay.
So I didn't climb the Kilimanjaro, and I wasn't in the gym, and for that reason I'm going there, because I want to have a distance between us. I wanted to begin with saying thank you very much for the invitation. It's extremely honorable, it's extremely fantastic, but I revoke. It's extremely tough to speak after Philip. I mean, how can I and what can I say? Philip locuta, causa finita, I mean, that is it. I cannot add anything to that. For that reason, I'm just gossiping a little bit around the issues we are talking about, and he has touched upon. So if you don't mind, and you please don't listen. And let me just begin with giving a kind of a background why the issue of sovereign default is a sovereign restructuring proceeding is of highest relevance and is so incredibly important. I'm not talking about the news we read today about Greece. I'm not talking about the vote. When is it? Next Sunday on the 4th of December. And what's going to happen afterwards with Italy. And I'm not talking about that, but I'm talking on a general level. The financial architecture in this world has changed within the last kind of 5 or 6 or 7 years. Until the financial crisis, when it began, the main pillar of the global financial architecture has been the IMF. So that has been the lender of last resort. The IMF, it's not by happenstance that the Argentinian case that Philip mentioned, that Argentina, the first step of Kirchner, of him, has been to pay out the IMF in order to get rid of the pressure from the IMF, in order then to develop the game with Judge Griesa in New York. So the IMF has been the big player in the game, but this has changed in the last years, because now you have increasingly regional financing arrangements. You have something like the ESM, which is by far not the first. Before you had the BRIC states, which had something like a regional financing arrangement, and you have something in Southeast Asia. And we have developed it just a couple of hundreds of meters away here, the ESM. But what is much more important, the central bank swaps have taken over a decisive, probably the decisive role in the financial architecture seen on a global level. Having now not any longer the one single finance institution, but having several, you have, in addition, of course, as a consequence thereof, you have the problem of increased moral hazard, because now it's easier to get access to money. In order to rescue a country, there are additional institutions where you can ask for money and which are ready to support or to help you. Under these circumstances, it's essential to have an instrument which creates discipline among the sovereigns, the public, the official lending. And in this context, or this is the context we are talking about, when we are saying that we are looking for a mechanism how we can deal with a sovereign insolvency. Now I'm looking a little bit closer to the European situation, if you forgive me. There are two instruments. If you look back at what the European consequence has been from the Greek crisis during the last 6 years, they have built the new structure on more or less two instruments. The one is something which is kind of preventive. It is designed to establish fiscal soundness. So that is where you have all these six-packs, where you have all these various instruments which have been created. And you have additional, as the second pillar, you have this regional financing instrument, you have the ESM, and you have, it should be noted, even though it seems to be something different, but you mentioned this as well, we have the single resolution mechanism. So that is dealing with the banks. And the banks are so important in the context of sovereign insolvency, because banking insolvency is, as a matter of fact, sovereign insolvency. At least there's a huge threat. If we are looking back a little bit further down the road into the history, I, as a German, or those who are German here in this room, might know that the record holder not in tennis, but in getting his country bankrupt, is the King Philip II from Spain. And he managed, well, he was unfortunately king for more than 50 years, but he managed to get his country 3 times bankrupt. And at the third time, the German bank of the Welser, the family of the Welser and the Fugger, they went bankrupt. They disappeared. And that is exactly the same pattern what you had with the Irish Anglo Bank in the case of Ireland, what you had in Cyprus. It is this unhealthy correlation and interrelationship and an unholy alliance, or however you want to call it, between the banks as financiers of the sovereigns. And the sovereigns, in response, give privileges to the banks. And for that reason, this is one of the weak points. And for that reason, I mention in the context of the structure, of the existing European structure, not only the ESM, but also the single resolution mechanism. The unfortunate thing is, what are we going to do if both mechanisms fail? Many politicians tend to say, well, now that we have established, Schäuble for instance, now that we have established this, and when we start with saving, we will never come to a situation again in which Greece has been 6 years ago. This is open to discussion, it's open to disbelief, and I don't believe in it. And for that reason, I see the urgent need for establishing something like a mechanism. If we establish a mechanism, or if we think about creating a mechanism, we have, I would say, 3 problems. We have, particularly here in Europe, we have a transition problem. And this is what I say, kind of the depth of my own heart. I have come up with a proposal for how a procedure could look like. And I know that in the German Finance Ministry, they have discussed this in 2010 and 2011. Leaving aside for a moment that the ultimate counter-reaction against my proposal, the finance minister, or in the ministry, they were close to adopting this. The ultimate counter-argument has been that Sarkozy at that time said, I don't want to have anything which resembles an insolvency proceeding. This is an additional facet that we have outside of the United States, particularly in Europe, but it's certainly true also in Asia, that the stigma of insolvency, that is a no-go area. For that reason, in my proposal, I call the entire thing a re-solvency proceeding in order to indicate that it goes back to solvency. That's the best translation which I can think of the English word turnaround. Turnaround is wonderful. You are going, or you're heading against the wall. And you are going to hit unless you turn around. And then you go away from this. That's a much nicer word, but I didn't find any other translation, and for that reason I'm taking or hoping that resolvency will do, at least for a moment. So we have the transition problem in Europe insofar as we are now in this constant 6 years lasting situation of that we are close to the insolvency of resolvency of at least one member state. Once again, particularly today or particularly next week, it might be that we are talking about 3 or 4 or even more member states who are this close to a resolvency situation. To establish an insurance mechanism under these circumstances is probably not a very good idea, because the markets are anyway extremely nervous. They're observing, they know what's going on. And if now you would come up with the idea, oh, let's establish something which resembles an insolvency mechanism, probably wouldn't be a good idea. Therefore, you have to handle this issue some way, somehow. One of the possibilities would be a contractual solution, because that is somewhat easier. And I will come back to that in 5 minutes or so, or in a minute. Then we have something which is essential. I would call it a commitment problem. Since you said you are a believer in the religion of law, he is believing in law. So do I. Probably we all here in this room are believing in law. However, if you look a little bit at the reality as law is practiced outside of this room, of this wonderful institute, and if you just think briefly of the comment by the then French finance minister, Madame Lagarde, forget about the treaty. This is something which must have been a knife in your heart, who are such a friend of contract law. Forget about the treaty. I mean, this is quite something. The point I'm trying to make is that if you have established a mechanism which deals with the resolvency situation of a sovereign, then there must be certainty that this mechanism is applied. A friend of mine who is teaching public law in Munich, he calls the new tendency in legislation, the symbolic. He's talking about symbolic legislation. That's a wonderful phrase. Symbolic legislation is enacting laws about which at the time of the enactment you have the understanding, yes, I mean it, or more frankly, let's assume that we will apply it in case of need, or even worse, that you just enact a law and you say to your neighbor, we enact this law, then we can say that we have a law, but we'll never apply it. This is something what you can observe increasingly in modern politics. And that is where I begin to follow you when you're saying that I don't understand the modern times any longer. This is, I would say, this is a disease which has become now kind of a permanent status of health or of the situation of many politicians. I could bring, of course, a couple of many examples, but I don't want to bother you and to bore you. I'm sure that you can think of your respective problems of yourself. The third issue, so the commitment problem is a huge issue. If Europe would ever establish something like that, it must be clear that this is a credible threat. Credible threat means that it exerts really the disciplining function or the disciplining pressure which is necessary in order to overcome moral hazard. And then we have a third issue in the context of what we are talking about, the sovereign resolvency. We have the holdouts. The IMF is saying that all the IMF is putting it this way, the only reason why we need an instrument, a legal instrument, in order to cover this problem is in order to overcome the holdouts. And he has described nicely, and I know that in one of the previous lectures you had already the discussion of this Argentinian case, which, as a matter of fact, was in the end a battle between Christina Kirchner and Judge Griesa. And there you have the paradigm of the holdout problem. And the IMF is saying in one of its papers that you need an instrument in order to overcome, or you need such a legal structure in order to overcome the holdout problem. If this were true, then you could help, like the Belgians do, with a statute, with a simple statute. They have enacted a statute which says that if a holdout, they even describe it as a vulture fund. If a vulture fund is either suing or trying to enforce in Belgium, then the courts are obliged to permit and to decide not in favor of the vulture fund, not above the sum or the amount of those creditors who have voted in favor of the debt restructuring. That would mean, in the case of NML, forgive me, that was wrong. The Belgium law says the vultures may not receive more than the purchase price. So NML, in the end, has won, I think it was the aggregated amount of 1.3 billion. And the investment has been something around 250 million. I'm not expecting that you are mathematicians, but you see the difference. There is a huge gap between 250 million and 1.3 billion. So there's a lot of gain to be made in this context. And the Belgian law says if NML tries to enforce in Belgium, it would be permissible only to the amount of 250 million, because that has been the purchase price. And Germany is right now at least proposing, has promulgated, not promulgated, but has submitted, one of the parties has submitted a legislative request on a similar statute. And I understand that France is doing something similar. The alternative would be that you have collective actions and collective action clauses, and Philip has described them nicely. I'm not sure if the IMF is really correct with saying that we need the a legal procedure for overcoming just the holdout problem. I think there is more behind it. And the reason why I'm thinking of that is there is a nice quotation from the former German foreign minister, Joschka Fischer. He once said, he said something like 10 or 15 years ago, he said, quite wisely, if we do not solve the problems of the third world, the problems of the third world will come to us. We are now we have reached a stage of globalization, at least as of now. I don't know how much this changes within the next weeks or months. But as of now, as of today, we have reached a stage of globalization in which we, for our own benefit, are better doing to help the others. So it's not just the third world, the developing countries, but it's also true with regard to Greece and countries or Italy or whoever is joining into this line. And for that reason, I think that the procedure is, or the desirability of a procedure is not just there because of the holdout problems of the NMLs or the Elliots of this world, but also because of the rule of law. We have reached by now a stage in which the participation rights or the request for participation of the creditors, for instance, has reached a stage in which you, beyond the phenomenon of holdouts, in which you have to provide them access to the process as such. Insofar, I'm really convinced that we need something which goes beyond just the holdout problem. My own proposal, which I actually discussed here at the ESM, a proposal which I made together with a friend of mine from Madrid, professor from Madrid, Ignacio Tirado, is you would need for Europe just a tiny little amendment of the ESM treaty. The ESM treaty in Article 12, paragraph 3, which you mentioned, where Europe introduced the necessity and the force to introduce collective action clauses, just add a fourth paragraph saying that an additional clause should be the resolvency clause. And then you would need, and that is on a contractual basis, then you just would need the fulfillment of this Article 12 and paragraph 4 by having all contracts, all loan contracts. I would go even beyond the bond contracts, the bond issuances, that you includes a so-called resolvency clause, which says more or less, in case of a default, the sovereign is permitted to file with a resolvency court. Then you need a resolvency court. I would establish. My preference would have been to establish it here as a special chamber at the European Court of Justice. But I was told nobody here in this room will ever experience this because it takes ages before the court is changing anything, and therefore my proposal is do it at the Permanent Court of Arbitration, and then set up rules of procedure for this resolvency court. And there you have the procedure pretty much along the lines that Philip has described. So these are, I have a few more remarks, but why should I? And I think I end here, and I'm really looking forward to your discussion with Philip. Thank you very much.
As I don't have any mic, I just move to open the floor. Maybe Philip would like to react to the proposition immediately made by Christoph before I open the floor. No? No idea on this?
I don't think there's a lot between Christoph and me, to be honest.
Okay, so I open the floor for questions or comments on this, maybe on this resolvency.
Resolvency.
Yes,
right.
the word is not that natural, so
true.
so we have to accustom to the ideas, the resolvency court. So, do you have any question? Yeah, please.
I think it's a lot between Christoph and me, to be honest.
Okay, so I open the floor for questions or comments on this, maybe on this resolvency. The resolvency court. So, do you have any question? Yeah, please.
I think there's a lot between Christoph and me, to be honest.
Yeah, please.
Hello, my name is Loïc Aubanel-Lorrain, and I am a PhD student in Paris 13 and research fellow here at Max Planck Institute in Department 2. I have two questions. The first one is for Mr. Wood, and the second one is for the second speaker. In the bankruptcy proceedings, normally in the corporate bankruptcy proceedings, and as I know, from the international point of view, the relationship between the trustee and the national court are very describing in a certain way that there is a separation of the role of national court and the trustee. So what I mean is that national court, when the trustee acts, the acts of the trustee regarding the bankruptcy are not considered the acts of national court. And the consequence is that the acts of the trustee regarding the bankruptcy are not attributed to the state, and there is not responsibility of the state. But you just brought up a new notion of sovereign bankruptcy. I was wondering how the relationship, what's the relationship between the trustee and national court during the sovereign bankruptcy? And my second question is that regarding collective clause action, I was wondering what are the benefits of this contractual approach as regard the cost of debt restructuring? Thank you.
Thank you very much. I mean, as regards to your first question, thank you very much for your comments as well, which are very interesting remarks which you made. The first is that in a sovereign bankruptcy, there isn't a trustee involved at all. There's no liquidator. There's no representative of the creditors at all. And any contract which is the result of this exchange of bonds is dealt with typically by the national courts named in the bonds, and which are very often either English or New York law, which between them have a large slice of it, so that they are really international public utilities. They don't really belong to either New York or England, and that's just a habit, you know. They're public utilities. And there are other very important legal systems which are used. So when questions come up, those issues have to be resolved typically in the named courts, or bonds normally provide any other courts which have jurisdiction. Another very important governing law is German law as well, and French. So there are lots of. So anyway, it's resolved by national courts. There have been calls for having an international bankruptcy court, mainly in the context of making decisions which are made now by the IMF about the fairness of the deal. And I think that the problem with that, for me, is that a legal court, like the WTO tribunal, for instance, or ICSID, are not equipped to make that kind of decision about what the financial deal is. None of them ever do. They give opinions on, they interpret contracts and treaties and things like that, but none of them, even WTO, they don't deal with financial terms which have got to be fought between the debtor and the creditor. Now, as regards the collective action clause, the whole point of that is to, as in an ordinary democracy, is to bind all of the creditors. Because if you have a large body of creditors who refuse to accept the exchange of bonds, then you've got all these creditors running around trying to attach assets and effectively ruining the deal, which everybody wants, you know. 80% or something want the deal. And so if you can't have a system whereby you can cram down and override these holdout creditors, you know, the deal may not work. And so that's why it's such an important step to have some financial democracy, which effectively does that by majority voting.
So you have answered already the second question, which was actually
sorry.
posed to me, but that's fine.
Sorry.
And for that reason, just let me add, the collective action clauses, or the history of the collection action clauses is interesting. It was invented for something like over 100 years ago in England. They used it, and it was not used in New York. And then in 2001, the IMF all of a sudden came, because of the Argentinian crisis, came with the proposal of this SDRM, which was called SDRM. As a matter of fact, we met for the first time in Washington at the IMF when we were discussing the SDRM. And it was then, rumor has it, and it's a very likely rumor, that the Wall Street was opposing a contractual approach. They didn't want to have it, and they preferred the softer solution of collective action clauses. And ever since, you have it under New York law, and I think Mexico was the first country who adopted them, and ever since you have it, it's now standard. The advantage is that you get all the counterparties, the bondholders. You can address all the bondholders. The disadvantage of introducing collective action clauses is, first of all, and Philip mentioned this as well, it takes decades until you have a full coverage, because now there are outstanding bonds which, you said something of 600 billion?
900.
900 billion, which are collective action free. So it takes just decades before you have all included. And there is something else, what I personally dislike with the collective action clauses. If you look at the creditor classes of sovereigns, then more or less typically you have 4 different classes. You have other sovereigns. Most prominent sovereign right now is China. Secondly, you have private banks. Third, and there you have the interrelationship, which I mentioned before, the unholy alliance between the banks and the sovereigns. Then you have the multilaterals. These are the World Bank and the IMF. And you have finally the rest, and that's called the private sector. So if you look at the history of sovereign lending, you see that it's shifting through the decades, through the centuries, through the millennia. It goes from private sector to other countries, to private banks. And in most cases, it's a mixture of all of them. And the multilaterals now for the last something like 70 or 80 years. I don't know, the Bretton Woods institutions came into existence something like 80 years ago. So ever since we have those 4. And the solution of the collective action, or the collective action clauses, is dealing only with one of the 4 groups. I mean, we have, for the other sovereigns, we have the Paris Club, and we have for the banks, we have the London Club. So insofar, we have 3 different institutions, in quotation marks, institutions which are dealing with the breakdown, with the resolvency of this country. And under these circumstances, that's one more argument, for me at least, why we should need to have a uniform procedure in order to get rid of this mixture.
Björn Laukemann from Max Planck Institute. I have a question to Christoph Paulus to pick up your idea of the resolvency court. If such a court were to be implemented, what would you say could be the design of the court in terms of its structure and in terms of its powers? And would you still draw the analogy to a banking system, because you said, okay, there are similarities? Thank you.
Thank you very much for the question. I'm increasingly struggling with the terminology. I stopped now to call it a court, because, particularly among lawyers, I should stop talking about the court, because we have not a court. I want to have a body of experts who know how to run the state. And for that reason, my judges or supervisors or controllers or however, or trustees, I don't know how you better call it, they would be prominent ex-presidents, those who know how to run the state. Because I need this expertise that they can find out where you have to look, where are the weak points in running a state. So they need to have some experience. If you have them, controlling, I would have them not deciding the problematic cases. For that, we have courts. And however we deal with that, you might give them the power of having mediation possibilities. I mean, resembling the WTO tribunal, the conciliation panel. You could establish something like that. They would just supervise. They would be the umpire, like in tennis, the referee who is saying this is inside, that is outside. The important thing is I would keep them even beyond the agreement on the plan, even though with the conclusion of the plan, things seem to be over. But, and at this point I have to ask, do we have Italians here in this room? Unfortunately, I did ask this question. I have to be a little bit careful. I call it actually, apology, I call it the Berlusconi effect. You have to deal with the Berlusconi effect. Because in 2012, he managed 3 times in 2012 to get concessions from Merkel and Sarkozy under the promise, in Brussels, while they were in Brussels, under the promise that he would make some changes in Italy. And he had forgotten these promises when he was back in Rome. So in order to supervise, to get things nevertheless transferred into reality, I still would have this body, this Resolvency Court in charge, because they would have the power to revoke the agreement, which would have the consequence that if the sovereign doesn't fulfill its own obligations to which it has itself obligated under the agreement, under the contract, under the plan, that they would lose their position and that the debt burden would increase from 25% back to 100%. So this would be one of the main powers in this context. Thank you very much for the question.
Thank you very much for your presentations. You addressed many issues, many technical issues, contractual, institutional, collective action clauses, immunity, attachment of bank accounts, etc. This is one side of the problem, but there is always the political dimension. And the political dimension escapes a little bit the law. I learned it directly when I was in the Troika process with Portugal. The same applied also to Greece, that agreements between the international lenders and the national governments are not made on the basis of law. They are made by memoranda of understanding, etc., and outside of parliament, because a government doesn't need the agreement of a parliament for signing an MOU where huge political consequences are finally agreed on. And this brings me a little bit back to the technicalities. I think we can progress there. This is certainly possible. I see the collective action clauses a little bit more positive than you, Christoph. But this might also be to some extent speculation, as we have not so much information about the bonds which are running around the world, let's put that way. But when it comes to the political part, the law is more or less out, and it's very difficult to separate both. I would like to learn a little bit more from you concerning this side of the problem. And I have a very technical question for you, Philip, because you addressed one very specific point which was quite of interest for me. Tomorrow I will be on a conference on the seizure of bank accounts. And you said, well, one way out might to get an attachment order on the proceeds of future bonds against the state. Would this be possible in, let's say, in England? In Germany, it wouldn't be feasible. So I would be very interested to see whether it's really a way out for creditors, but I'm doubtful whether the law even permits this.
Well, you deal with those questions, Christoph. Would you? Thank you. I think I agree with you on the last point there. I think most countries you can't do that.
Definitely. Let me add to what you said about the political situation. When we were together at the IMF, this was a lesson which I learned ever since, and which was really telling. We were sitting around and we were discussing point by point, and then it came to the point where we were asking who has the right to file a petition. And in corporate insolvency law, it's both the debtor and the creditors. And that is a nice balancing, because each side can threat the other one. If you don't comply, I go to the court, to the insolvency court. And the general counsel of the IMF at that time, he said, no, we can't do. And we said, you should, because it has a disciplining function, and for that reason it would be wonderful. He said, no way. And we were asking him, why not? He said, a simple reason. Who is the biggest shareholder of this institution? With the blocking minority, it's the US, who happens to be the biggest debtor country in this world. And for this political reason, it never works. And even though it looked from the legal side as a perfect solution, because it's a nice balancing, we learned that for political reasons, there's no way. So this is just in order to endorse what you have said. How can you deal with it? If you look back at the history of sovereigns, Philip mentioned something like 150 years. My history begins in the 3rd century BC, because Rome in those years, or in this century, has devaluated 3 times. It was the time of the Second Punic War, which is a clear indication of that they were bankrupt. They couldn't escape this problem unless they devaluated. For that reason, we have this long history, and we have this miraculous ignorance and laziness of the lawyers who never filled this out. Needless to point out that Germany has been twice bankrupt in the last century, and which is worthwhile to remember in certain discussions. For that reason, yes, if you look at this history and you see how similar cases are treated entirely different because of political circumstances. There's a nice dissertation in German which deals with 5 different state insolvencies in the 19th century. And it's comparing the Greek insolvency. Nobody knows exactly if those were 4 insolvencies or 1. It could be that it was 1 continuing insolvency or 4 different ones. With the Egypt case, Egypt was treated by the same creditors entirely different because of the Suez Channel. So it would be time to overcome this. But politicians are extremely reluctant to do that. And it always takes, that is the common history that Philip shares with Richard Gitlin, with me. We are interviewed always when a new catastrophe comes up. And then politicians, as I mentioned earlier, in the finance ministry, they discuss my proposal. And then it's a window of opportunity of probably 1 week or 1 day. And we are waiting for the situation that it's so horrible that they're saying we need a structured procedure. That's all what I can say. The politicians certainly are not happy with it. But it might be that we come to the situation where we find out, it would be horrible if we experience this from next week on here in Europe. But it's not entirely out of the game. That the politicians then recognize it would be better. It needs, the Germans, particularly the Germans, they played a role, let me put it this way, a certain role in the Greek crisis. We all know about it. It was a bad role, it was an understandable role, however you do describe it, from which angle you look at it. But if there's one politician who has some decisive power, who recognizes or thinks a little bit further that it just takes Volkswagen and the Deutsche Bank to collapse, then we are in serious troubles. if this were the case, if he would think through and would then, under these circumstances, say, oh, I don't want to be treated like the Greek have been treated by us. I mean, that would be one of the possibilities. Okay, end of answer.
Thank you very much for the interesting presentation. I have a question regarding the contractual approach in general. Given the difficulty of establishing a formal mechanism for sovereign debt restructuring, it seems that the contractual approach seems to be more feasible in terms of facilitating sovereign debt restructuring. But as you mentioned, this may work for future sovereign debt contracts, but not necessarily for those existing contracts without the necessary clauses. Not all existing sovereign debt contracts have a collective action clause and similar necessary clauses. So for this kind of sovereign debt instruments, what is the way forward, or how to address the problem of holdouts and similar problems? Is the experience of Greece of introducing a collective action clause or similar clauses retroactively would work for other countries as well?
I think the answer to that last question is that it's only if the bond is governed by domestic law that the country, the sovereign debtor, can change its own law and have that recognized, subject to some very basic sort of human rights style, unconscionable, you know. Your other question, what do we do about the legacy bonds? We just take a deep breath, to be honest. And I think people hope, well, you know, except for Argentina, we've always coped, and creditors have accepted deals with very high proportions. But of course, if that proves not to be the case, then that would definitely strengthen the hand of those who think that contract is not doing it because of these legacy cases. There's a lot of arguments about that because the 900 will run out in about 10 years. And so some people say, oh, it'd take 10 years to get people to agree. Look, I don't know. But, you know, this sort of thing, I think my view is, could be sparked off by a single, really dramatic event. Just one. I mean, the arguments over the pari passu clause of all the technical things, you know, but that raised such mayhem. Nobody, of course, understood it, you know, frankly, but it raised such mayhem in people's minds. And that really pushed through a lot of changes, which I personally welcomed. I thought the CACs were a really good idea. That's because I believe in democracy, you know. And so, you know, if there is another major event, and if there is conduct in the course of that event, which is not consistent with, my friend here was saying, you know, the political realities which we all have to accept. But if that doesn't follow, and we have a lot of instability, then that could strengthen the hand of those who want legislation.
Can I just briefly add to that? The decisive point, of course, is what Philip had said. If you have the bonds out under your domestic law, that's the reason why Japan is still working and acting on the capital market, and why they are not kicked out, despite the fact that they have 200% the ratio of public debt to GDP.
239.
Ooh, 239. Okay, which is actually a killer. But since it's running under Japanese law, they can always enact a statute like the Greek ones, the Greeks have done in 2012. As a matter of fact, it was copied after the German Indenture Act, Article 23, paragraph 2. Someone behind there? Apologies.
Thank you so much. So my name is Gong. I come from the ESM. Actually, I have one comment and one question for Professor Paulus. The comment is on the moral hazard. I'm an economist. So I somehow disagree with the motivation, but I go to the same conclusion with you about the insolvency quote. So about the motivation, so you were saying that actually moral hazard is growing nowadays with so the expansion of the global financial safety nets. However, I acknowledge that from the supply side, there are more emergency liquidities in the markets. However, we also need to say that the demand is also bigger because countries face more problems nowadays compared to 30 years ago. Just to give a very concrete example, so like global financial crisis, it represents roughly 100% of the world GDP in 1980. However, today it's 300%. So the issue is also on the demand side is also different. Now, I mean, I have very maybe stupid question about legal question, which is, do you think to set up these insolvency courts, is it sufficient only to change the ESM treaty, so the Article 12, or actually a revision of the Treaty of the Functioning of the European Union necessary as well? Because the Article 150 prohibits actually any bailout, and if we set up this solvency court, actually all the member states of the ESM will bear, I mean, eventually bear the financial cost, and this is prohibited by the Article 125. Thank you.
Thank you very much. As to your comment, yeah, you're right. The demand is bigger. However, if you look at the global structure, the global financial structure, then you see enormous disproportionality. You have this in the Southeast Asia, this, what is it, Ho Chi Minh City? Right. And you have the BRICS and you have the ESM. There are huge areas on the globe which are not covered by them. So insofar, you have another inequality in the distribution of financing possibilities. This again, bringing back to the quotation by Joschka Fischer, when we are not solving this problem, the problems will come to us. So insofar, again, I would see this as an argument that we need a orderly structure. We need a structured, legalized procedure. As to your Article 12, yeah, okay, it's a very good question, actually. If you have to change the TFEU, I think it's not the case, because it's a purely contractual thing. If you have incidentally, have you been there already at the ESM 3 or 4 years ago when we were? Okay, so we had been discussing this. What I still see as completely outside of the TFEU is that you set up such a resolvency court, which is a possibility for any contract party to make reference to and to submit itself or to subdue itself to the rules of the resolvency court. And all what we need is the alignment with the ESM, so that the ESM would be permitted to say at some point of its lending policy, if you do not comply with this or that, you are ripe for the resolvency court. That's all what I need the amendment, the statutory amendment for.
Pierre Konak, I'm a law professor at the University of Luxembourg. You mentioned the situation of Japan, and to a certain extent the US is moving in this direction. And I came across an interview by Paul Turner, the former head of the FCA. He said something quite provoking, but I thought, okay, it's not stupid at all, actually. He said, actually, well, Japan is not so insolvent because when you say it's indebted to the amount of 239% of GDP, it's an accounting trick, it's an accounting dream, because a large part of this debt is owed to the central bank. So essentially, the Treasury issues bonds, which are being bought immediately by the central bank, and which is the state basically, and then the money goes into the economy, so you have money creation here, and the money is not expected to be reimbursed at any point, and you could pass a law, the government could pass a law and say, well, all the money which is owed to the central bank, the Bank of Japan, is cancelled. All the bonds are cancelled, so that the true state of indebtedness of Japan is not as it looks like to be, but it's much lower. And if you take the US, for instance, who is buying the US 10-year treasuries, so far? It used to be China, but they went down. They are sellers of U.S. Treasuries. So the Federal Reserve is buying this stuff. So you could create a huge amount of indebtedness, which on the face looks huge, but which looks like at the end like an accounting trick, which can be wiped out, just by a law. So I would like to have your view on this. In this situation, I don't mean they are not over-indebted, because they are over-indebted to the private sector also, But to a certain extent, isn't this just an accounting trick? Not to mention that if the Bank of Japan, for instance, who is the most advanced in this game, continues to buy the Japanese debt, at the rhythm it does it, well, I understand that in 2020, it will be almost the only owner of Japanese debt, which means they could also cancel it, What do you have any view on this? Question for both of you.
Go ahead.
Well, they're creating money, aren't they? I think it was John Galbraith, somebody like that, who used some such term as, it's repellent how easy it is to create money. All you do is you send an email to whoever you're buying the bonds from, a bank, and you can create as much money as you've got time to write out all the noughts. You just send an email and you say, thank you for your bonds. Here's your price, which is, we've credited your account with 1,000 billion, whatever it is, and you've created 1,000 billion additional money. And so effectively the circle in Japan is that, it's the creation of money. And I suppose the reason why it's not inflationary, which is what you'd expect when you create money, according to theory, is the reason, well, I think it's, I don't really know for sure, but remember that when Fannie and Freddie were bought by the US in 2008 or whatever it was, they had 42% equivalent of mortgages, which was nearly half the GDP of the United States. And they created that amount of money just by sending an email, And the currency didn't inflate. And so in the context of Greece, the fears which Germany had about the impact of creating money, which they could have done via the EFSF, I felt were possibly, I think Germany was more worried than they needed to be in light of the shadow of 1923, which prevented them from doing things like that.
It's a trauma. It's German trauma. Absolutely. I have no view on that because I'm not an economist and I don't know enough about it. But it is, for me, an indication of this unholy alliance between the banks and the sovereigns. And for that reason, I mean, when we are talking about the BRRD, forgive me if I'm allowed to make this slight detour, but the BRRD, which was designed for getting the taxpayer never again to pay anything for it. And look at the Greek situation. The first real case of test is Greece, is the Monte dei Paschi di Siena. And what happens? It's bailed out. And for that reason, this is another example actually of symbolic legislation. And this interrelationship, this financing. I mean, it's the Fugger and Welser on the one side and the Habsburger on the other side.
Excuse me. I would like to know. I would like to know more about the cost of debt restructuring. How can you reduce it?
How? Any idea? How can we reduce? Are you talking about the costs, or are you talking about the debts as such? The cost of reducing
the debt, the cost that when we instigate debt restructuring, there is a cost, and the whole cost of the procedure.
Are you talking? Are you asking for the procedure that I'm proposing? Okay, I see. Well, in my understanding, I developed this idea. I began to develop this idea together with a friend of mine from New York, and it was designed for the United Nations. It was, again, it's one of those happenstances. We made presentations in 2008 at the headquarters in New York, and the last question we dealt with was how expensive is this for the world, for the United Nations? And we made a calculation and we said the resolvency court is something around $1 million per year, which is close to nothing. And then we made it already into the preliminary final document of the Doha conference, which was supposed to take place in December 2008. And then Lehman filed for bankruptcy. Then we had the crash. And it was then the Japanese delegate who said, we extinguish everything. We delete everything out of the final document, which costs just a penny. And for that reason, our proposal was then kicked out. And I revitalized this proposal then and adapted it to the European situation, and now we are back here. So I would say setting up the resolvency court is, again, something where we talk about costs of 1 million. You need an office at the Permanent Court of Arbitration. You need one president who needs to be paid in full and staff. This is it, period. And then the rest, the trustees, judges, however you call them, they are forming a pool, but they are not getting paid for being members of the pool. They are getting paid from the moment they are appointed by the president after the filing of a petition. Then he appoints out of that pool something like 7 or 9 judges, and they need to get paid. And I've not yet calculated how expensive that is, but when we are talking about 3 million per year, which needs to be paid by the sovereign who's filing for the resolvency, I mean, that would be the cost. Or let it be 5 million, I don't know. So I wouldn't say that this is the hell of a cost.
Now, obviously, compared to the amounts which are at stake in these cases, exactly. It's nothing. It's a drop in the ocean. So obviously, I don't know. I guess we will have to see where this kind of proposition go in the future. In any event, I'm very grateful that you have shared these ideas and your reflections on this topic with us tonight. I propose that we go on with the more informal discussions as drinks are waiting for us outside. But before, once again, thank you very much for this very lively lecture and discussion. And I think that the audience shared with me this feeling. Thank you.